the problem is you'll get a lot of like discount trademarks, trademark fast, trademark now, whatever it is.
And those are not lawyers, or they are?
I don't really know what they are because they have to have some sort of pseudo lawyer connections because they fill out the applications and I see their names all over it. But they don't fill out forms properly. They don't take the time to assess like whether or not this is something that can be trademarked or something that may have already been trademarked by somebody else. They'll take your money and just do it without even really looking. So I have had people call me to clean up that sort of mess too. It's just a whole disaster. Now, starting the process though, say you called me today and we wanted to start the process. What I do is obviously I'll take you through a consultation and then we'll talk about what type of business you are, what type of classifications you're looking at and things like that. And then moving forward, I would write up a whole assessment letter. I do this for all my clients. I write up an entire assessment letter for the chance of likelihood of success of your application. That's a mouthful.
So, I think I saw that on your website. So it's suitability and availability is something that you're kind of looking at, right?
Yes.
Okay.
And the biggest factor that the USPTO looks at too is likelihood of confusion. So if your mark is going to be confused with somebody else or maybe confused.
And like a lightning bolt or something that maybe some other brand is using.
Perfect example. Yep. And just to kind of go off on a little side thing here too, like talking about confusion in the marketplace, when you build an LLC in Florida, for example, you can have something extremely similar to somebody else. So like Tampa Bay Lightning, for example, stick to the hockey theme, I guess.
Sure.
Tampa Bay Lightning, say it's Tampa Bay Lightning LLC. But if you wanted to do Tampa Lightning LLC, you could probably have that in Florida. Now, trademarks is totally different. The USPTO is much, much stingier about it. You cannot do anything that may cause confusion in the marketplace. So if you wanted to do Tampa Lightning and trademark that, first of all, I'll tell you right now, they're not going to do it.
Never going to happen.
But yeah, it's just things like that. And now that can also apply to your logo as well. You could have a totally unique one, but say you have a lightning bolt that looks like the lightnings, and they're going to say, we're not taking this because it's like this. They could say you can amend it, and there's a whole process for that too. Yeah. But it's you may still not get there. And you don't want them to come back to you. And when I say them, I mean the USPTO. You don't want them to come back to you, and it's called an office action when they pause your application and say, you need to amend this, or you need to clarify what you're talking about here, or so on and so forth. And if they do that, there's a chance that you may not get your application or your trademark. And if they do that too, you're not getting your money back either.
Oh, shoot. So when you get that letter back, that's a sign or an indicator that you may not be getting your trademark.
Correct. And there's several reasons they send you the office action is what it's called. If there's a likelihood of confusion office action they send to you, it might as well be a death sentence because it's like, I think like, I'm just pulling this number out of nowhere, but it's like a 10% chance you can bounce back from it.
Go back to the drawing board.
Yes.
Then. Yeah. So then before I cut you off, so it sounds like you kind of go through the evaluation to make sure that doesn't happen before the application is even done. Is that right?
Yes. Okay. Yes. And then once I, make the client aware of what, the likelihood of success is going to be, say we proceed, and then I go through and I fill out the application, which asks what classifications are we dealing with here? Basically give us your logo, your company name, your whatever you're trying to trademark, slogan, whatever it may be.
Sure.
And then pay us. So and you pay them too. And then the application's done, and then you wait a long time.
I was just about to say, so waiting wise, what is kind of the timeline when your application has been submitted, everything's wrapped up in a bow, you've paid your fees. Now what? How long does that typically take?
It is about 11 months. Okay. And that's usually what they say. I think the latest one that I heard back from was about mid-November. And that was a trademark application I had filed on January 30th.
Wow.
So it takes, it's a long time.
And what is happening during that process? They're searching databases of all the various different slogans, trademarks, and things to try to determine if it's similar to something else.
Yep.
Wow.
And you get an examining attorney who works for the USPTO. and they have to take every area, every aspect of your trademark application and compare it to other trademarks that are live or even pending. So there could be others that are waiting to be approved as well. And again, if there's confusion or any issues at all, you could get a kickback, and then you have to amend and make your argument as to what's going on and so on.
Okay. So I was browsing your website when you're looking at the trademarks page, and I saw something about suitability. So obviously availability, I understand the trademark has to be available in order for you to trademark it. You can't, I had a great idea, just do it. Well, sorry, it's taken. But suitability, I wasn't sure I really understood that. So are there parameters in terms of what you can and can't trademark? Like, is there some, can't be obscene, it can't be, pornographic or things like that, or what does suitability really mean? Or am I thinking of the wrong thing there?
Actually, I'm not sure about the pornographic side of it. I've never actually ran into that.
No one said, no, you can't do that. That's too much.
As far as suitability goes, it has to be something that you are using currently in commerce, or something that you are intending to use in commerce.
Gotcha.
So you can't trademark stuff that prevents people from trademarking everything.
Yeah.
And then nobody else can get something else.
So you can't try to blanket the whole industry of something you're not even doing.
Correct.
I gotcha.
Correct. And it's also like similar to, people ask me a lot about domain names as well too. Because I don't know if you're familiar with that, but people buy up domain names all the time just to get them, just so they can have them, maybe sell them later or whatever.
Right.
Trademarks, you can't do that. You actually have to be using it or show proof that you intend to use it. I guess, domain names as well too, because when people buy up domain names and they have them, I have had trademark clients call in and say, hey, I want this. Am I even able to get this trademark because somebody has this domain name?
Yeah.
Domain and trademarks, like, they're totally different worlds. They have nothing to do with each other. You can get a trademark that somebody already has the domain name, or you could get, I know Nike.com is probably taken, but theoretically, since it's already trademarked, you could get Nike.com as a domain name.
Gotcha. Okay. Interesting. So I just wasn't sure if there's like things that are off limits, like you'll never be able to get that trademark, aside from obviously if it's taken, just like certain words or phrases that the powers that be might say, nah, it ain't happening.
I don't know about like swear words and stuff. I would imagine you're able to, but I actually have not run into that.
Yeah,
so
that's interesting. Something to think about, obviously. Yeah. And again, I'm thinking of like, bumper stickers. You see some catchy bumper stickers, but they're inappropriate. They're sometimes pretty crude. But it's like, can you trademark that? Maybe, I don't know.
Maybe. Yeah. I'll do that, but I'll be careful what I put in my search bars. So you don't know what's going to pop up.
That's true as well. All right, cool. So then we talked a little bit about the law that governs it, because you mentioned the USPTO. But I obviously won't dive into that because it looks like we've got a question. I want to make sure we get our caller, but I'll come back to that in a second. We have Jen from St. Pete. Looks like she's on line 1. Jen, can you hear us?
Yes, I can.
Hi, Jen. How are you?
Good. How are you?
Good. Did you have a question for Andrew?
Yes. I have a company that I have had for several years. I never trademarked the name or anything. I've got my social media and all of that, but I got registered on Sunbiz. How can somebody come and take my name if it's registered on Sunbiz? Because nobody else can get it if it's on Sunbiz. Isn't that true?
That is true. In Florida, however, the USPTO and trademarking is nationwide. So you could have somebody who has it trademarked in Massachusetts, for example, and they could send you a cease and desist letter. And if, again, they have it trademarked, it's enforced, sea to shining sea. So you have to, you could be in trouble with that. I definitely recommend getting it trademarked as soon as you can. But that's, again, for, like I said earlier, it's the shield to protect against somebody like that coming along and, forcing a costly rebrand.
Exactly.
But if it's in Florida, because it's the name Tampa Bay, or the words Tampa Bay are in my name, so I don't think anybody in like New York or anything is going to get it. Am I protected from anybody in Florida from taking my name and putting it on T-shirts or something, even if they don't register on SunBiz?
Yeah. If you trademarked it, even though it says Tampa Bay, it would still.
No, but I didn't trademark it. I just registered it on SunBiz.
Well, at that point, you wouldn't have the trademark protection. So if somebody did have it, say it was Tampa Bay Window Company. I don't know. I'm just throwing a hypothetical out there. But if it were that and somebody put that on a T-shirt and you don't have it trademarked, then you don't really have a right to enforce you don't have a right to stop somebody from using it in commerce.
Right. Sounds like SunBiz alone wouldn't do the trick, Jen.
Okay. All right. I guess that was my question. Yeah. Thank you.
So it sounds like you need to be calling Andrew to try to talk about some trademark.
How do I get a hold of you, Andrew?
My office is open 9 to 5, Monday through Friday, and the number is 727-316-5333. And call and we can talk for sure.
Okay, thank you.
You're welcome. I hope that answered your question, Jen. And it is actually a great time to take a quick break. The lines are open. So if you have any more questions for Andrew about trademarks, your business, maybe you are starting a business or you've already been successful and you're trying to figure out if maybe you need to jump on the call and talk to Andrew about something that you want to trademark, call us now. The number is 727-441-3000. We're going to take a short break and we'll be back in the studio with Andrew Silver on FLA Law on the radio.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Perenich, Caulfield, Avril Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Perenich, Caulfield, Avril, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
And we're back with FLA Law live on the radio. We are the personal injury attorneys at Perenich, Caulfield, Avril, and Noyes. You can find us at voiceoftheinjured.com. And as you know, we are live in the studio with our special guest tonight, who is Andrew Silver. He practices at the Goodwin firm, and we are talking about trademarks tonight. So hopefully you've been tuned in, getting some good information from Andrew so far. It's been an eye-opening show because I don't know a whole lot about this. And so if you're business owners or you know someone who's a business owner, tell them to turn on the radio, jump on our Facebook live stream and listen, because I think this is really beneficial for you to understand, because quite honestly, I know a lot of business owners, but I don't know if any of them are trademarking their names, their slogans, and things of that nature. So this is a really good show for them to tune into. All right, before we got our caller that called in, we're talking about the USPTO. So is that kind of the law that governs it, or is it a search database? What exactly is the USPTO?
They are the government office that I guess oversees it all, and they hire their attorneys that review applications and stuff. They do handle patents as well, but patents as a whole, that might as well be on Mars, because I don't know patents. But
that falls under their branch, kind of.
Yes, but it's all under one office. And they review all the applications. They're the ones that send you the office actions if you have some amendments that need to be made, and hopefully they're the good guys in the end that approve you too. So
Exactly. So because, like you said, this is Sea to Shining Sea, this is kind of a nationwide search that goes on when we're looking at trademarks. So is it safe to say then that this is federal law in terms of what's governing the whole trademark issue?
Correct.
Okay.
Yeah. That's the common term would be like federal trademark infringement.
Yeah.
So if you have an infringement case, more than likely it's going to be it's going to fall under federal law. You're going to have to take it to federal court. And
Gotcha. So then theoretically, does that mean you could help businesses all over the country, or you only can help people in Florida?
Yes, that's one beauty of, one of many beauties of trademark law is that the Florida bar doesn't just confine me to the boundaries of Florida. It's I can trade. I've done Massachusetts. I've done Virginia. I think I had one in Minnesota. So you can do it all over.
Quite interesting. It's almost like a little bit like Social Security disability, which we do at our office. You can basically take those cases all over the country because the law is federal law that we're looking at. That's good to know. That's pretty interesting. So then you mentioned it already a little bit. As far as there's something called patents, but we didn't talk about copyrights because that is a little bit confusing in my mind. I think I understand the difference between a patent and a trademark, so we don't necessarily need to go down that rabbit hole. But I don't know that I really understand the difference between a trademark and a copyright.
So a copyright is pretty much exactly what it sounds like. It's your right to copy an original piece of work.
Okay.
So like a book, you can write a book, you copyright the material in the book, but you trademark the name. So the name is how you're known, but the book itself is the piece of work that you are
That's what's copying. Got it.
Now, the Federal Copyright Act, and I will disclaim this by saying I'm not an expert in copyright, but I do know the Federal Copyright Act protects original works from plagiarism.
Okay.
And it protects against that without filing an actual copyright.
Right.
Now, you can file a copyright. I'm not very familiar with the protections that provides that the Federal Copyright Act doesn't. But what I do know is that if you are going to do something like write a book or create a TV show or I think maybe even like baked goods and like cooking recipes, that may fall under copyright as well. But if you are going to make an original piece of work like that, document it. Document that, hey, even if you write in a journal, say, hey, I wrote this on this date. Because if you do ever need to prove that somebody took this idea from you and you don't have the actual copyright, that's a good way to prove, hey, look, on this day and time, this is when I came up with this book and this material and so on.
Yeah.
That way you can protect yourself from a copyright.
So I see sometimes people will have a word or phrase or a book or something, and they have that little C symbol, the TM or the C. And I don't even know if they actually have the trademark or the copyright, but they put that on there. So is that kind of somewhat of an indicator that you should not use this or not copy it or what have you? I've
read conflicting sources on what all this means, because there's the TM, the C, the R, the whatever. From my understanding, the TM doesn't mean anything.
Okay.
Trademark, if the little TM, you can use that too, even if you don't have the trademark, because it literally doesn't mean anything.
It has no effect.
In the eyes of the USPTO, the little TM, and the little C as well. You can do that. You can use it, but it doesn't really mean anything. The circle R, that means trademark.
Okay.
And that's the legit one, that you are registered trademark. That's what the R is for. It's you have a registration number with the USPTO. You are a registered trademark. So if you see the circle R, that's legit. And if the USPTO catches you using it without the registration, and you're using the circle R, they have a problem with that.
Oh, okay.
So
you actually got to be pretty careful with claiming that something's trademark when it's not.
Yes. And the USPTO knows that if you have the little TM or the little C, they don't know what you're doing. They don't really care. Yeah. So the circle R, that's the big one. And I tell my clients too that like you can use it, the C or the TM if you want. Yeah. Before you actually get registered. As once you're registered, you got to put the R on it. Yeah. But you can use a little TM just to kind of fend people off if you want. If you feel it's necessary, then go ahead. Yeah.
So is there such thing? I know when people are inventing things or creating products, they go after the patents, and then there's something that's like patent pending when they're kind of going through that process. Since you said it's 11-month process almost, is there something that you can do as a business owner during that pending period, like trademark pending, so that people can't really maybe attack you during that time frame?
You can put people on notice that you do have a pending trademark. It doesn't offer you any protection. You don't get the protection until you're actually registered, unfortunately.
Sure. That makes sense.
If so I talked earlier about office actions coming back to you. If they say, hey, there's a similar mark, but you trademark first, you're good. You have more right to that trademark. There is some case law that discusses use in commerce. So if you've used it first, if they used it first, but you trademarked first, it gets a little convoluted. It's a little confusing. The general census is that if you trademark first, if you file your application first, first in line, you're probably going to get it.
Okay, so, good to know.
Yeah.
Is there anything else that might cause your application to be denied other than being too similar to another trademark?
Yeah, your attorney screwed up on the application.
Okay, fair enough.
Luckily, I haven't had that yet. So that particular office action, I will answer your question shortly, but I have had somebody call in who had a previous attorney file something that was too similar, and I had to defend against it.
Right.
And that's why I said earlier too, if you get the likelihood of confusion, you're
kind of dead.
Pretty much screwed.
Yeah.
So, but yeah, so yes, the other things that it could really be anything. There was one, I actually did file an application. I didn't realize it had the little TM mark on the logo, and they kicked it back and said, you got to remove that mark.
Remove that.
They said the mark's okay, but you just got to remove that one. So, okay, that's easy. Yeah, I guess they could ask you, classifications. There was a little confusion on one of the trademarks I did too. It was dog apparel or apparel, like dog apparel. Like right? I'm making it sound confusing because it was.
Because it is confusing.
So when I asked the client, I said, did you want apparel for dogs or like apparel with dogs on it? Because I have in my notes here, dog apparel. Now I'm thinking in my head, I'm like,
which one is it? Yeah.
And they're like, yeah, we want to sell T-shirts with our dog logo on. I'm like, okay.
Not clothes for the actual dogs to wear.
Yeah. Luckily we were good in that situation, but it comes back to you and they want clarification.
Because that matters. I gotcha.
And they're going to say, what do you mean by dog apparel? And I say, let me ask my client. I'll be right back. So.
Okay. So you got to be kind of specific then, obviously. Yeah. And I could imagine it's almost like they want to make sure that you're not a dove in the chocolate dove lane because there's already a dove there. But maybe if you're a dove in some other space, you might be able to get by. Is that
exactly
a fair assessment?
Yeah.
Okay.
Yeah.
I gotcha. So that makes sense. Any other reasons why you might get denied?
I got to think.
Because I'm thinking, obviously, the similarity issue is definitely going to be there, but it's always hard when it comes to like images. I feel like the smiley face or some things are so common, so normally used.
The use in commerce is another one that
that's right. You have to actually be using it.
I mean, that's definitely one. If you file it or even so intent to use as well too. So if you're not using it, you have to prove that you are intending to use it. And then 6 months after, say you get it registered, they're going to come back to you, and it's not an office action at that point because you're already registered. But they're going to say, hey, we need proof that you're actually using this now. So they watch.
Okay, so that was not my next question. So who's monitoring the use of this? Is anybody watching like, hey, you can't do that, that's already trademarked? Or is that on you to really monitor your own trademark?
That is on you to monitor your own trademark. For the most part. Now, you will have an examining attorney from the USPTO, for example, the intent to use stuff.
Yeah.
They'll come to you and say, hey, have you started using this yet? And you say yes or no or whatever.
Yeah.
Now, say you are Tampa Bay Window Company, that fun hypothetical we used earlier.
Yeah.
And somebody else starts using Tampa Bay Window Company, but you don't say anything to them. And then 6 years later, you realize they're taking all your business, and then you complain. The USPTO is going to say, you didn't do anything about this 6 years ago.
Wow.
And again, this is all hypothetical, but yes, you do have to, it's called policing. You have to police your own trademark.
Yeah.
And a good example of that is Band-Aid, because Band-Aid is actually, that's the brand.
Yeah, that's the actual name.
But, even me, like growing up as a kid, I was like, Band-Aids are just.
You called everything a Band-Aid. Yeah.
A hockey one is Zamboni. Zamboni's a brand name, but everybody just calls it a Zamboni, even though some of them are not Zambonis.
Right.
So that's just a poor job of policing it, because once it comes to that too, you kind of, you can have the trademark. Like Band-Aid still has a trademark for Band-Aid, but it's pretty much useless at that point. Yeah. So
I gotcha.
That's how the USPTO stays on top of this stuff too, to avoid like trademarks kind of building up that no one's using, because they want to push commerce. They want commerce to flow. They want people using what they are actually claiming they use.
Yeah. So then let me ask you this, because it almost sounds like, I'm going to throw out this legal term for the listeners who may not understand it, but it almost sounds like you can adversely possess someone's trademark or kind of be a squatter and use it for so long, and now it becomes yours as opposed to theirs. And you could, then what would you do? So I guess that's my question. So technically, someone can use your trademark, but does that take away the trademark you already have, or are they able to now trademark it because you're not using it? Like, how does that work?
Well, it doesn't take it away, but it just kind of renders it useless, because what do you do in that scenario? You send somebody a cease and desist letter.
Right.
Now, at that point, if you send somebody, say a third person starts doing it, you send them a cease and desist letter.
Yeah.
The court is going to, assuming they have all the facts, they're going to say, you didn't do anything about this, with this other company.
Yeah.
We can't enforce this against them now. So does that answer the question?
Yeah, I think I get it. So then you really can't enforce it. It doesn't have any teeth anymore.
Exactly.
Almost.
Yeah.
I gotcha.
Yeah.
So then we're talking about the United States, obviously, but what about, and this may be getting way far afield, but I'm just automatically thinking of like China, where they make everything there cheaper. They take all kinds of things and rebrand it and sell it for dirt cheap. Is that something that a trademark, you have to watch that kind of stuff too? Or is that something, I'm thinking of something different?
Yeah, you can. Most of the time it's, they do have like American, I'm not familiar with business entities, so I could just be making this word up. But they have like,
I won't be able to tell the difference.
American conglomerates. You would basically go after them. And you could try. And then I guess at that point, it's so far-fetched too that, like, I shouldn't say it's far-fetched, probably happens all the time. But at that point too, if you do your diligent efforts to try to stop it and you can't stop it, I still think you would have some sort of enforcement power behind your trademark, because you're doing you're doing everything in your power. So,
gotcha.
That's something I haven't come across yet. And
because I was wondering, I saw something similar on some social media platform, I don't recall which one, where it was like a influencer of some kind who was selling a product that, I can't say whether she trademarked it or not, but she had a business and these were the things that she was selling. And then she found some other entity out of China or somewhere doing the same thing. So they were taking her branding, her packaging, her everything, and selling it as if it were theirs. And she was, of course, going on rants and making all kinds of content about all the things she was going through to try to stop them from doing it, but she seemed to be unsuccessful. So I was wondering, does the USPTO kind of only have its power here in the States, or is it something that can? They
do have international powers, and they do have we talked earlier, Dove, the United Kingdom, they're trademarked here and internationally. There is an international side to it.
Right.
I don't have any experience with that.
Gotcha.
So I can't comment too much on that. But what I will say is what your hypothetical earlier, or I guess it wasn't hypothetical, it really happened. But that's why you document everything. You got to make sure when you create a brand, when you create a piece of work, whatever it may be, make sure, hell, even if you take a video of it and say, this is the day I made it, just have some sort of documentation, just in case things like that
comes up later.
Scammers are everywhere. They're everywhere. They're all the time. Internet, online scammers, they come up all the time. So just the more you document for your business and your, creations and your logos. I can go on and on, but just the more you document, the better you're going to be protected for sure. Right.
And so obviously this may not be something you've had to encounter yet, but is there litigation involved? If someone's in Texas, I'm in Florida, we're fighting over the brand. I've got my videos, I've got my evidence, but they're ignoring my cease and desist. What happens? Do I file a lawsuit against them, or is that how it works?
And typically, it would be injunctive relief. You want to get them to stop using whatever they're using because it's taking away your business. You got to prove that you're losing money. Most of the time you're losing money, you're losing customers, you're losing whatever it may be because of this.
The damages.
There was a big one, and we actually, and this is a reach here because I do law school. So, but
who remembers that? I forgot everything once I took the bar.
Yeah, there was one here in Florida that was actually pretty big, and it was 2 local breweries that had their breakfast IPAs or whatever it was, and they were both brown cans. They both had like a sun on the can, and one sent the other a cease and desist, say, "Hey, we have this trademark. You can't use it." And they said, "Yeah, you have that trademark, but you don't necessarily have this trademark. Like we have a little orange stripe or whatever it is." So there is wiggle room too, for sure. But I know ultimately the infringing company was held to have infringed, and they took their customers and they had to pay them a lot of money. But
okay. So that's the kind of case that you can take on.
Yeah. And they're detailed. They're very intricate, I guess. But
it seems that way.
Yeah. But
the key is start documenting and getting your evidence as soon as you start this business or this product and you're building it up. That you need to be documenting in the event that something like that happens.
Yeah,
right?
And if anybody's using your brand name or something similar enough, they don't have to be using the exact same thing. But if it's something that you're looking at it and saying, "Hey, that quick Google search reveals puts us right next to each other," and how can you tell the difference? You need to get on them. You need to tell them right away,
right away.
"Hey, this is we have this trademark, or it's pending." But most of the time, you want to wait till it's registered so you actually have the power behind it.
Right. So if a person does recognize that, can they send their own cease and desist, or should they contact an attorney first to help with that, the language and the what could end up being litigation, I guess?
Can you guess what I'm going to answer?
I can guess, but I want you to tell me.
You definitely want to contact an attorney and get an attorney to write a cease and desist. I mean, realistically, yeah, you can, but it
on
happens
your
all
own
the time.
letterhead, it may not have the same strength.
Yeah, exactly. So
I think we do have a Facebook question for you, Andrew. It is from Edward, who's asking, "Why should I hire you instead of one of these cheaper online companies that can do this sort of thing?"
Yeah, we touched on this a little bit earlier, but it's definitely, I don't want to call them scams because I think they may be businesses, but they don't take the time. I mean, they call it trademark fast for a reason. They don't take the time to
get what you pay for.
Yeah. They don't take the time to review and say "Hey, there's a likelihood of confusion with this, small detail of your logo, or your slogan has one word that may be confused for this." So when I do these assessments, I make sure that as the applicant, because you're the applicant, I'm just filling it out for you pretty much.
Right.
But I make sure as the applicant that this is out there. This could be a problem. So I put you on notice. And if you want to proceed, we can proceed. But otherwise, again, I'm letting you know that this, other company or other trademark could be an issue for you in the future. And then ultimately it's your decision to decide whether or not to go through with it. Going back to the scam companies, I guess I'll call them, but the Trademark Fast or Trademark Now, it's definitely, they do it fast. They don't take the time to make sure it's a successful application. They don't. I actually don't know if they even follow through if you get an office action. They may just do the application and then you're on your own.
They leave you there.
And then the office actions are very. They might as well be the application as well too, because they're very detailed responses that they need back too, that you don't want to screw up on, because they could either ask you to pay to fix your screw up, or they could just flat out reject you. So that all plays into it too. And I would imagine if they're trademark fast, they don't stick around. They probably fill out the application and then you're on your own.
Right. They're fast and out the door. So then, and that brings up a great point that you mentioned earlier in the show. When that happens, you hire one of these fly by night or, fast, companies that don't do the due diligence that you would get with an attorney. Now you have to hire an attorney anyway to come back and fix the problems that were created by this fast, application.
Yeah. And I charge basically my same rate.
Yeah.
Actually, I do charge my same rate for cleaning up the mess, because it's a lot of work too. And it's just a lot of bad news at that point.
Yeah. I mean, I tell clients similarly in my own practice, you might have had a great case had you come to me initially. Now you've got a mess, and sometimes it's things that we can't go back and fix, unfortunately.
Yeah. Yeah.
Looks like we may have a follow-up question. So do your fees include the office action response, or is that something separate?
Me personally, the way I do it is I do it like one application is a fee. So whatever my fee is, I take it from start to finish. So I will take you from the beginning of the assessment letter, the beginning of the application, all the way to, say there is an office action or whatever. My fee covers that. What my fee doesn't cover is the application fee itself.
Mm-hmm.
So
just like a separate cost.
Yeah. But also, so there's follow-ups too. So like I said, if you have the intent to use, the USPTO is going to come back and ask and make sure you're actually using it.
Yeah.
Then there's a between years 5 and 6, you have to re-up and renew and basically file like another.
Oh, okay.
It's like a.
So it's not a lifetime warranty then.
Correct. Yep.
Okay.
So there's years 5 and 6, and then there's years 9 and 10.
Okay.
So between those years two, you have 365 days to file your. I actually don't know the actual term for it, but it's hey, I'm still using this form. So you got to send them more photos. You got to send them more evidence that, hey, I'm using this. This is still I'm using it in commerce. If you haven't,
you're not
at
just
that point,
sitting on this trademark when somebody else who's actually active in the business could be using it.
Correct. Exactly.
That makes sense. What if someone dies with a trademark? Can you get it from them? Or do you know if that's possible?
I don't know. That's a great question.
That's it. Because I don't know if you go through that process and you do the application, you get the trademark, and then you never use it. I guess you got to wait till that 5 or 6 mark because they won't reapply or recertify. So I guess that's probably when that would.
Yeah, I guess
maybe that would get cleared up at that point.
Yeah, definitely. Yeah. And most of the time too, the companies are the ones that do it.
Yeah.
So as long as the company's still around and
that survives. Yeah. That makes sense. Well, those have been some great questions, Edward. I hope that answered your question as far as the follow through and the fees that you can expect. Is there anything else that you would like to tell our listeners as far as cost or anything that they might expect if they decide they wanted to retain you?
No, just protect yourself, protect your business. Rebranding sucks. It's a lot.
You don't want to invest that money in starting over. Yeah,
it's a lot more work, and it's a lot. I mean, you build a brand. It's something you love. It's something you care about. It's your creation. And then somebody tells you have to stop. That sucks. So you don't want to do that.
Well, thank you, Andrew. It's been a pleasure. It was great having you on the show tonight. We had some great questions come through. That is it for tonight. It's been FLA Law live on the radio. We were here with Andrew Silvers from the Goodwin firm. Please tell our listeners one more time how they can find you.
Awesome. Yeah, we're the Goodwin firm, 727-316-5333. We're located in downtown St. Pete, and trademarks, employment, and pet rights.
And pet rights, that's right. So everybody, I hope you have a happy holidays. We will likely be off the air next Tuesday, but of course we'll be right back every Tuesday at 5 p.m. after Christmas. Hope you have a great night, and we'll see you soon next.
WTAN, Clearwater.
FM 106.1.
WDCF, Dade City.
FM 102.3.
Listen.